The National Prosecuting Authority will today argue that the then acting Free State High Court Judge President, Nompumelelo Gusha, erred in her application of law when she granted a discharge to the accused in the Nulane case. It relates to the nearly 25 million rand spent by the Free State Agriculture Department for an allegedly fraudulent feasibility study from Nulane, which ultimately led to the controversial Erred dairy farm project. And Newzroom Afrika's Mnisi is now joining us live from Bloemfontein. What's at the core of the arguments that will be presented by the NPA, Linda, considering that the Bloemfontein High Court had said that even if you look at some of the evidence, that it was all riddled with errors?
Yeah, so Aldrin, the state or the NPA is expected to argue that the judge erred in her application of the law when granting specifically the discharge, ultimately acquitting the accused. Recall that a discharge is what is termed in law a Section 174 application, and this is when the accused feel that the state has not given or produced enough evidence for them to defend themselves, so feeling the need that there's no case to answer to. Of course, the court weighs the evidence that the state, would have brought at that particular stage of the trial, and if it deems that they have not met the threshold, then it grants, the Section 174, the discharge. But if it feels that there is evidence that the accused persons can answer to, then it declines placing the accused on their defense. In this particular case, the judge felt that the state had not even met the barest. These are the words that she uses in her judgment, saying they did not even meet the barest threshold for a possibility or a possible, a conviction, thereby leading to that judgment. The state says this is a grave miscarriage of justice, because had they been allowed to take the stand, then of course, they would have possibly gotten a conviction. But the judge in that particular judgment says that she couldn't have declined that particular application on the hopes that the accused would take the stand and incriminate themselves. She also highlighted some of the evidence that was presented, Aldrin, like the documentary evidence, saying some of it was not authenticated, it was copies, and therefore fell short and was inadmissible as evidence in the court, as trying to, or rather as in the state's bid to try to prove the allegations of fraud and money laundering, therefore dismissing all of those charges. You also recall that there was a Section 204 witness. Now this is a witness that has turned state witness who was implicated in this, and they get immunity in exchange for an honest account of what happened. But the judge felt that that particular witness, this is the manager of the agricultural department in the Free State, was evasive in his evidence. He was hell-bent on not taking culpability, and that's one among the points that the state has taken issue with the application of the law in terms of that Section 204 witness. The court finding that even issues like corroborating evidence, it was not there, but solely looking at the evidence of the 204 witness, there wasn't really much that the court could take. It did not take the state's case forward. So the NPA will this morning argue that the judge erred in her application of the law when it comes to those aspects, Aldrin.